Major breaking news and great news out of the Commonwealth of Pennsylvania. The United States Court of Appeals for the Third Circuit, covering Delaware, Pennsylvania, and New Jersey, have just denied en banc review requested by the Republican Attorney General, believe it or not, Dave Sunday, who actually asked that a 2-1 decision in favor of the Second Amendment be overturned. Crazy. We've covered this before, but let's talk about the great news today, which is the Third Circuit did exactly as I predicted they would do here on the Four Box Diner, rule for the Second Amendment. Let's talk about it. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thanks to the 2025 Gundies Awards. Thank you for your support. I hope to continue to do good work in this area the rest of the year. All right, major breaking news, exciting news. This is a potential Supreme Court case, although I can't imagine that the Commonwealth of Pennsylvania and the Republican Attorney General, David Sunday, would want to continue this fight. Shocking. Let me tell you what happened here. As you may recall, we covered this a week or two ago, and I was shocked then. And I would be shocked again if a Republican Attorney General that claims to be good on the Second Amendment were to seek cert on this case of Lara versus basically the state of Pennsylvania. This case of Lara deals with 18, 19, and 20-year-olds and whether or not they have full-blown Second Amendment rights like any other American adult. You know, those 18, 19, and 20-year-old Americans who have the right to vote, who have the right to get an abortion, who have the right to enter into contracts, who have the right to enter the military and die for their country. You know, those young adults that can get married and so on. Right, those same young adults, under certain laws in the state of Pennsylvania, are denied the ability and the right to have full-blown Second Amendment rights, i.e. the right to keep and bear arms. Specifically, the Lara versus Pennsylvania case here dealt with whether or not 18, 19, and 20-year-old Pennsylvanians in the state of Pennsylvania had a right to carry guns in the event that the governor of Pennsylvania declared an emergency. And by the way, as I recall, COVID was a statewide emergency for like 2.5 years. There's all these emergencies declared by the governor with wavy the hands, wavy with a pen. Next thing you know, you have an emergency. And in those situations, the Pennsylvania state law said that 18, 19, and 20-year-olds were denied the ability to carry guns, handguns in public to protect themselves in the event of a declaration of an emergency. The details don't matter so much. What does matter is this, that a 2-1 decision several months ago by the United States Court of Appeals for the Third Circuit, covering Pennsylvania, New Jersey, and Delaware, came out and said that indeed the Second Amendment protected the full-blown Second Amendment right to keep and bear arms of 18, 19, and 20-year-old young adults in Pennsylvania and beyond. This is a powerful ruling in favor of the Second Amendment, and it had some other powerful parts to the opinion by the three-judge panel in Lara, in addition to the fact they ruled in favor of the Second Amendment. Because remember, I've explained to you before, and this is very important to keep in mind, when you win an appellate case, when you win a case, it's not just important who wins the case, it's equally important the way you win the case. There can be broad rulings or narrow rulings. It can be on something that you can use in the future. It can be on something you can't use in the future. Here, the three-judge panel by the Third Circuit did some really good stuff. In addition to ruling in favor of the Second Amendment, in addition to vindicating the rights of 18, 19, and 20-year-old Pennsylvanians, which is great, it went beyond that, creating very powerful Court of Appeal precedents that we in the Second Amendment community can use all across this great land. For example, the Lara decision by the panel several months ago said that you look to 1791 as the relevant time period for figuring out how to interpret the Second Amendment. This is extremely good because in 1791, at the time of the founding, when the Second Amendment and the Bill of Rights was adopted, there were very, very few gun control laws, which means there are very few gun control laws that the anti-gun movement today can use as historical analog laws as a basis for trying to establish a well-regarded or well-representative, well-established, long-standing exception to the text of the Second Amendment, which is very hard to do, and the burden is on the government to do so, as you know. So it's very good that the Third Circuit today refused to hear the rehear, really, the three-judge panel ruling in favor of the Second Amendment. So what exactly happened today? Well, as you may recall, after that powerful three-judge ruling in favor of the Second Amendment, ruling for the young adults, claiming and pointing out that 1791 is the relevant time period for assessing and interpreting the Second Amendment and for the purposes of looking for historical analog laws of gun control laws that are exceptions to the text of the Second Amendment. Obviously, this is all great news and a great precedent. Nevertheless, what happened was the Republican Attorney General, David Sunday, the Republican Attorney General of Pennsylvania, for some ungodly knows reason, why, as I've covered in a previous video, decided it made sense, either politically dumb or legally dumb, to ask the entire Court of Appeals for the Third Circuit to rehear the three-judge panel ruling in favor of the Second Amendment. He wanted the entire Third Circuit to rehear this argument and rule in favor of gun control over the Second Amendment. Now, why on earth is a Pennsylvania Republican Attorney General David Sunday doing this? It makes no sense politically, because no anti-gunner is going to rule or vote for a Republican out of Philadelphia or many parts of Pittsburgh, right? They're going to vote for the anti-gun Democrat in Philadelphia, no matter what Republican Attorney General David Sunday does in terms of advancing gun control. So politically, it can't make any sense, and certainly the Republican Pennsylvanians that are good on guns, good on the Second Amendment, can't possibly like what David Sunday did here. It's just politically a dumb move as I see it. And legally, of course, it was totally stupid, because as I predicted in my video several weeks ago, there was virtually a 0%, not a 0%, but like a 50 basis point, right? Half of 1%, or if you're in finance, 50 basis points possibility that the Third Circuit was actually going to grant rehearing en banc on this case dealing with young adults in the Second Amendment. It was almost no way it could realistically occur. And yet David Sunday thought this made legal sense. So I don't understand why he did it either politically or legally, unless he somehow wants to become like an anti-gunner, which I highly doubt is my guess. But whatever the reason is, the Attorney General of Pennsylvania, the Republican, decides to try to overturn a pro-Second Amendment ruling by that three-judge panel in the lower case. And today, breaking news, the Third Circuit absolutely said no way, you know how. They denied the request to rehear this case en banc, which is great news. So what happens next? Well, what's going to happen next is this. The question is, whether or not the state of Pennsylvania, the Commonwealth of Pennsylvania, presumably the Attorney General of the state, David Sunday, the Republican, he's going to have to decide whether or not to seek cert from the U.S. Supreme Court. And again, my view remains the same. If I were advising Dave Sunday, I'd be like, drop this like a hot potato. Drop this like a hot potato. Absolutely don't seek cert. Just leave it be. Why? Because again, politically, I don't see how it helps you with your Republican base. And ultimately, your anti-gun base in Philadelphia is not going to vote for you either way. So where's the political upside for you? And then legally, there's no way the U.S. Supreme Court, in my opinion, is going to grant cert in this quirky Pennsylvania case for several reasons. One of which is that it arises from a quirky statutory scheme in Pennsylvania dealing with whether or not you have an emergency. And if there is an emergency declared by the government, you can deny 18, 19, to 20-year-old certain Second Amendment rights. That was the case before the Lara decision, of course. So it's such a quirky decision. I don't think that John Roberts or the Supreme Court will want to take this particular case, this particular vehicle, for ultimately resolving the 18, 19, and 20-year-old, whether 18, 19, and 20-year-olds have full-blown Second Amendment rights. And if you compare it to other cases involving young adults in the Second Amendment, like the Worth case out of the Eighth Circuit, the Reese case out of the Fifth Circuit, among other things, I don't see how the Lara case out of the Third Circuit will possibly be granted cert by the United States Supreme Court. So again, if I were advising the Republican Attorney General David Sunday as to what to do, I would simply stop the bleeding, stop digging the hole deeper, just forget about it, don't seek cert. Don't enforce the law. Let this opinion stand. Let this final judgment stand against the Commonwealth of Pennsylvania and just move on. Don't make it worse politically for yourself. Don't make it worse legally for yourself, because you're not going to win at the Supreme Court. There is no way you could win this in the Third Circuit. Why you saw rehearing en banc to overrule a pro-Second Amendment decision was just, in my view, dumb. And you certainly don't want to get smacked around by the U.S. Supreme Court, because they're going to deny your cert petition. So don't do it. That's just my opinion. Obviously, people make decisions for all sorts of reasons. I don't know everything, but on this one, I'm pretty sure this is a dead end for the state of Pennsylvania. And that's very, very good news for the Second Amendment, and very good news for people and 18, 19, and 20-year-olds in the state of Pennsylvania. So all good news all around today. There you have it. Okay, folks, hope you enjoyed today's show. Make sure you follow me at X at 4boxadonner. Don't forget to subscribe to YouTube and Rumble. We're trying to get to 200,000 YouTube subscribers. We're working hard on that and getting close. And I thank you again for your support. I look forward to talking to all of you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.